Welcome back, guys. Support me by clicking the subscribe button and getting me to 1,000 subscribers. Thank you so much. 26 receptions in a single postseason. No rookie in NFL history had ever caught that many passes in the playoffs. Not Rice's teammate Travis Kelce, not Jerry Rice, or any receiver who had come before him. Rashee Rice did it in his first year on a $6.5 million rookie deal, catching passes from Patrick Mahomes in a Kansas City offense that had already won 2 Super Bowls and was hunting a third. He was 23 years old and the 55th pick in the draft. By February 2024, he was a Super Bowl champion with a postseason record that nobody in the league's history had touched. The Chiefs found their receiver at a bargain. That part of the story is true, and it's the last part that goes uncomplicated. What happened after that Super Bowl is a question the NFL has spent 2 years answering in pieces. A press conference here, a leaked statement there, a spokesman's quote released on a Friday afternoon. None of those pieces, laid out in sequence, tell the story the league wants you to hold. Because the full sequence doesn't raise a question about Rashee Rice. It raises a question about a policy, who it was built to protect, how it counts the cost, and why in 3 years of applying that policy to one player, it never once applied it to his employer. Rice is in jail right now. He will be until June 16th. The Kansas City Chiefs have not lost a single draft pick, a single cap dollar, or a single game because of anything in that sequence. That gap is not an accident, and it did not start with Rashee Rice. The version of this story the NFL gave you is this. In March 2024, Rashee Rice was involved in a serious crash on a Dallas highway. People were hurt. Rice accepted responsibility. He hired an attorney. He cooperated with the legal process. In July 2025, he stood in a Dallas County courtroom and pleaded guilty. The NFL launched its own investigation under the personal conduct policy. It concluded that Rice had violated the policy. Commissioner Roger Goodell's office handed down a 6-game suspension without pay, effective at the start of the 2025 regular season. Rice did not appeal. He served the suspension. He came back in Week 7. The Chiefs stood by him through it. General Manager Brett Veach told reporters the suspension was not a surprise to the organization. They had planned around it. They believed in their player. Rice returned, caught passes from Mahomes, and worked toward reclaiming the career that had stalled. The system had worked. A player made a serious mistake, faced a serious consequence, and the league moved forward. That is the account the NFL gave, the Chiefs gave, Rice gave. It is not wrong exactly. It is just missing most of what happened. Here is what the sequence actually looks like when you put it in one place. March 30th, 2024. Rashee Rice drives a Lamborghini Urus at 119 miles per hour on North Central Expressway in Dallas. The car makes what prosecutors described as multiple aggressive maneuvers around traffic before striking other vehicles and triggering a chain reaction collision across 5 cars. 2 people are hospitalized. Rice and 4 other men leave the scene on foot. None of them check on the people in the other vehicles. They leave a Lamborghini and a Chevrolet Corvette, both belonging to Rice, on the highway behind them. That is the event at the center of everything that follows. Not a poor decision in the abstract. 119 miles per hour, 5 vehicles, 2 hospitalizations, and a choice made by 5 men in the immediate aftermath to walk away. The NFL did not act immediately. The personal conduct policy's standard process held. Wait for the legal case to resolve before initiating discipline. So the 2024 season began and ended with Rice on the field. He caught 24 passes for 288 yards across the first 3 games before tearing his LCL in Week 4, placed on injured reserve. July 2025. Rice pleads guilty in Dallas County Court to 2 third-degree felony charges, collision involving serious bodily injury and racing on a highway causing bodily injury. The sentence, 5 years of deferred probation, and 30 days in jail, with the jail time to be served at any point within those 5 years. That flexibility, the ability to choose when the 30 days were served, was part of the plea agreement. Rice's legal team negotiated it specifically so that it would not interfere with his football career. August 2025, the NFL suspends Rice for 6 games without pay. He forfeits $421,824, a little over one-third of his 2025 base salary. The suspension is the baseline punishment under the personal conduct policy for a first offense felony involving bodily harm. Rice does not appeal. The Chiefs confirm they knew it was coming. October 2025. Rice returns in Week 7. He plays 8 games across the rest of the regular season. The Chiefs miss the playoffs. January through April 2026. Rice's ex-girlfriend Dakota Jones files a civil lawsuit in Dallas County alleging physical abuse across a year-and-a-half period, grabbing, choking, and hitting, including while she was pregnant with their children. The NFL opens a second investigation under the personal conduct policy. On April 3, 2026, the NFL closes it. There was insufficient evidence to support a finding that he violated the personal conduct policy. NFL spokesman Brian McCarthy, April 3, 2026. May 19, 2026. A routine probation check. Rice tests positive for marijuana. The flexibility built into his jail sentence is gone. A Dallas County judge orders him to serve his 30 days immediately. Rice is taken into custody in the 194th Judicial District Court. He will remain there until June 16th. He has played 28 games in 3 years of professional football. That is not a run of bad luck. That is a timeline. And timelines have a logic to them, a cause and consequence chain that once you see it assembled in one place, raises a question the NFL's press releases never address. At every point in this sequence where a cost was assigned, who was doing the assigning and who was exempt from receiving it? Now count what this sequence has cost Rashee Rice. The $421,824 forfeited during his 6-game suspension is the number the league puts in the press release. That is the visible cost, the one that gets reported. The less visible cost runs forward from it. Rice signed his rookie deal on June 15, 2023. 4 years, $6,495,208 total. Signing bonus of $1,723,788. Guaranteed money of $3,519,025. In 2026, the final year of that deal, he earns a base salary of $1,635,710, with a cap hit to the Chiefs of $2,660,658. Before the crash, before the suspension, before any of this, Rashee Rice was tracking toward the market for wide receivers with legitimate WR1 production, inside one of the most efficient passing offenses in the league. That tier, for a receiver with his profile and his quarterback, runs between $35 million and $45 million per year. Jackson Smith-Njigba, Rice's own 2023 draft classmate, lives at that number now. Rice's second contract negotiation begins this offseason. It begins with 28 career games, 5 years of probation, a recent stint in county jail, and a franchise that, as of right now, has not committed to anything beyond his existing deal. The policy cost him $421,824 in forfeited salary. What it actually cost him cannot be calculated precisely, but it runs in the tens of millions. Here is what makes that number worth sitting with. Rice had done what second-round picks almost never do. He had made himself indispensable inside the league's most watched franchise before his second season began. The 2023 postseason record was not a fluke. Per route, he was running at 2.40 yards, an efficiency marker that holds up against any receiver in the league. He was 23. He had Mahomes for the foreseeable future. The contract window for receivers peaks in the years before 30, and his was wide open. That window is now closing from two directions at once. The production clock that every receiver races against kept running while Rice was suspended, injured, and incarcerated. And the leverage a player brings to a second contract negotiation, the clean record, the availability, the franchise's dependence on him, has been eroded at every point where the conduct policy made its presence felt. None of that erosion cost the Kansas City Chiefs anything on their books. Now count what this sequence has cost the Kansas City Chiefs. The answer is nothing that shows up in any official record. No draft pick was forfeited. No cap penalty was assessed. No fine to the organization appears in any league document. The Chiefs' dead cap liability, if they release Rice today, is $430,947, a number that exists because of how signing bonus proration works in rookie contracts, not because the league assessed any consequence against the team. Brett Veach told reporters the suspension was not a surprise. They had planned for it. In a league where 6 lost games from a starting receiver is a serious roster management problem, the Chiefs absorbed it, planned around it, and lost no competitive position because of anything the conduct policy did to them. That asymmetry, a player who has lost tens of millions in career earnings and is currently incarcerated, playing for a team that has lost nothing, is not by itself evidence of a broken system. Players bear legal consequences for their own actions. That part is straightforward. What is not straightforward is what the policy was built to do and why it was built to do it that way. Go back to September 2014. A security camera video surfaces from inside a casino elevator in Atlantic City. It shows Baltimore Ravens running back Rashee Rice knocking his fiancée unconscious. The NFL had already seen the video. It had suspended him for 2 games. What followed was one of the most damaging public crises in the league's modern history. Goodell acknowledged the 2-game suspension was insufficient. He then increased it to indefinite. A federal judge later called that second suspension arbitrary and ruled that Rice had been punished twice for the same act in violation of the collective bargaining agreement. In December 2014, NFL owners unanimously approved a rewritten personal conduct policy. It was presented as systematic. A special counsel for investigations and conduct would oversee initial discipline. An independent expert panel would participate in appeals. The baseline suspension for first offense felony violence was set at 6 games. The policy is comprehensive. It is strong. It is tough. Commissioner Roger Goodell said on December 10, 2014. There was one detail in the rewrite that generated less coverage than the baseline suspension number. Goodell retained authority over appeals. The commissioner, the same person whose original 2-game suspension in the Rashee Rice case had just been called arbitrary by a federal judge, kept the final word on every disciplinary decision made under the new policy. The special counsel oversees initial discipline. The independent expert panel makes recommendations. Then Goodell or his designee decides. The players' union objected. The NFLPA said any changes to the conduct policy should go through collective bargaining. The owners approved the rewrite unilaterally. Our union has not been offered the professional courtesy of seeing the NFL's new personal conduct policy before it hit the presses. NFLPA statement, December 10, 2014. To understand what the 2014 rewrite actually changed, you have to look at what it left intact. Before the rewrite, Goodell had wide discretionary authority and no formal process around it. The Rashee Rice case exposed what that looked like in public. A 2-game suspension for knocking a woman unconscious, then an indefinite suspension once the video surfaced, then a federal judge calling the whole thing arbitrary. The rewrite's job was to fix the optics of that discretion without surrendering the discretion itself. So the league hired a special counsel, added an expert panel, published a flowchart, set a 6-game baseline for specific categories of offense. All of it was real. None of it removed the commissioner's final authority. What the structure actually produced was a separation between who decides and who appears to decide. The special counsel decides initial discipline that is visible, on record, attributable to a process. The commissioner then has final authority on appeals. That is also on record, but it sits one step removed from the initial decision, insulated by the appearance of review. In the Deshaun Watson case, the league's own disciplinary officer recommended 6 games. Goodell's office appealed its own process's outcome and sought a full season. The appeal went to a panel appointed by the commissioner. Watson was suspended for 11 games. A system where one office can appeal its own process's findings to a panel it appointed and increase the punishment, that is not a check on discretion. It is discretion wearing the clothes of process. The Players Union has understood this since 2014. What the NFLPA wanted from the rewrite was collective bargaining. The conduct policy negotiated, not handed down. What they got was a unilateral announcement and a flowchart. The distinction matters because collectively bargained rules carry legal weight that unilateral commissioner policies do not. A collectively bargained conduct policy could be grieved, arbitrated, challenged in ways that constrain the outcome. A commissioner's policy can be challenged too, as the Rashee Rice and Watson cases showed. But the challenge goes to a judge the commissioner did not appoint, which is the only reason those players won. The NFLPA's position was never that players shouldn't face consequences. It was that the process determining those consequences should not be controlled by the same office that issues them. 12 years later, it still is. What this also means, and the league has never been pressed to answer it publicly, is that the same commissioner's discretion that can increase a player's suspension can also decide not to act against a franchise at all. There is no external trigger that forces the conduct policy to apply to an organization, no threshold a team crosses that automatically initiates a review of its employment decisions. The special counsel investigates individuals. The process was built around individuals. The question of what a franchise knew when it knew it and what it chose to do with that information has never once appeared in a conduct policy proceeding. Not in the Rashee Rice case, when the Ravens front office later acknowledged knowing more than it disclosed. Not in the Watson case, when the Browns signed a player facing 24 civil suits and guaranteed him $230 million before a single legal resolution. Not in the Rice case now. The policy's architecture makes that silence possible. It was not an oversight. It was a choice. That is the mechanism Rashee Rice entered in August 2025. And it is the mechanism his employer never entered at all. What the 2014 rewrite produced was a policy that looked like a system. It had steps. It had a council. It had an expert panel. It had baseline numbers. What it did not have was any mechanism that applied to franchises with real financial consequences. The policy covers players, coaches, team employees, game officials, league office employees, and owners. It covers everyone. But in the 19 years since the first personal conduct policy was issued, one owner has been disciplined under it. One. I have stated on numerous occasions that owners, management personnel, and coaches must be held to a higher standard than players. Commissioner Roger Goodell, letter to Jim Irsay, 2014. In 2014, Indianapolis Colts owner Jim Irsay was pulled over near his home in Carmel, Indiana. He could not recite the alphabet. He failed field sobriety tests. Officers found multiple prescription drugs in his vehicle, along with more than $29,000 in cash. He was charged with a misdemeanor, driving while intoxicated. The NFL suspended Irsay for the first 6 games of the 2014 season and fined him $500,000, the maximum penalty the league's rules allow for owners. In 2014, the Indianapolis Colts franchise was worth approximately $1.6 billion. $500,000 is 0.03% of that. In the same year, the policy set a 6-game baseline suspension as the minimum punishment for players convicted of felony violence. For Rashee Rice, on a $1.6 million average annual salary. 6 games cost him $421,824. That is a little over 26% of his annual income. The maximum fine the league can impose on the owner of a franchise currently valued at roughly $4 billion is $500,000. It has been imposed exactly once in 19 years for a misdemeanor DUI. Goodell told Irsay that owners must be held to a higher standard. The evidence from 19 years of the policy's operation says something different about how that standard actually works. Every front office in the NFL watched what happened to the Kansas City Chiefs across 2 years of Rashee Rice headlines. They watched the Chiefs lose their starting receiver for 4 games to injury in 2024, 6 games to suspension in 2025, and now OTAs and minicamp to a jail sentence in 2026. They watched the team absorb that, plan around it, and never once face a formal institutional consequence for continuing to employ a player with 2 active felony guilty pleas on his record. The lesson the policy taught them is the same lesson it has been teaching since 2007. Player accountability and franchise accountability do not operate from the same set of rules. They never have. The 2014 rewrite formalized that separation. It gave the policy the appearance of the system, while ensuring that the organizations employing the players remained outside any accountability mechanism with real financial consequences. A player facing a first offense felony under the conduct policy gets a 6 game baseline suspension and forfeits more than a quarter of his annual salary. An owner facing a misdemeanor under the same policy gets fined 0.03% of his franchise's value. The next general manager sitting across a draft room from a player with legal exposure will run the same calculation the Chiefs ran, because the policy gives them every rational incentive to reach the same conclusion. The player carries the legal risk, the suspension, the roster uncertainty, the contract leverage it destroys. The team carries the press cycle, a few news cycles of uncomfortable questions at the podium, and nothing else the league formally requires them to pay. That calculation does not require bad faith. It does not require anyone in a front office to sit down and consciously decide to exploit a player's legal exposure. It just requires reading the policy the way every team lawyer in the league reads it, as a document that tells you in precise financial terms where the accountability stops. And for 32 franchises, the accountability stops at the player's contract. Rashee Rice walks out on June 16th. He reports to a team that has not publicly committed to his second contract. He begins the final year of a 4-year, $6.5 million rookie deal, earning $1,635,710 in base salary. With 5 years of probation ahead of him and a negotiating position that looks nothing like it did when he caught his 26th postseason reception in February 2024. The personal conduct policy cost Rashee Rice $421,824 in forfeited salary, a second contract window that has been narrowing for 2 years, and 30 days in county jail triggered by a marijuana test on a probation agreement stemming from a case the league already adjudicated. Every consequence in that list landed on one side of the ledger. The policy produced that outcome because its structure allows it, because the franchise accountability mechanism inside that policy has no real financial teeth for owners, has never been used against an organization for its employment decisions, and was designed in 2014 to look systematic while keeping every consequential call in a single office. Roger Goodell is currently cooperating with a Florida Attorney General's subpoena tied to the Rooney Rule investigation. The league is in front of an external legal body for the first time in years on a question about its own internal policies. The conduct framework is not what that subpoena covers, but the same logic applies. What happens when the league's policies are tested by a legal authority that does not report to the commissioner and whose findings cannot be appealed to his designee? The conduct policy has been tested against exactly one owner in 19 years. The result was $500,000 in 6 games. Not from team operations, not from the franchise value, not from anything that constituted a meaningful organizational consequence. If it is tested again, does the $500,000 ceiling hold? And if it does, if the maximum penalty for the owner of a $4 billion franchise remains $500,000, what does Goodell's 2014 letter to Jim Irsay actually mean? Owners must be held to a higher standard than players. The record says otherwise. The one honest thing the evidence cannot yet answer is whether anyone inside the NFL's ownership structure has noticed the gap between that sentence and what 19 years of the policy's operation has actually produced. The personal conduct policy does not hold franchises and players to the same standard. It was not designed to. And the financial math of how it operates makes that visible in a way the league's press releases never will. If you've watched a Rice story this week and felt like something was being left unsaid, this is what was being left unsaid. The comment section is open. Tell me where the argument holds and where you think it doesn't. I will be in the